Imagine a world where your employer could demand you work 16 hours a day, 6 days a week, and the government couldn't stop them. That was the legal landscape, or almost, at the turn of the 20th century, profoundly shaped by one Supreme Court decision often called the forgotten case, Lochner v. New York. In 1905, the Supreme Court struck down a state law limiting bakers' work hours. The court invoked a concept almost unheard of today: substantive due process, essentially creating a constitutional right to contract freely, even if it meant harsh working conditions. This ruling dramatically curtailed states' power to regulate labor for decades, setting a precedent that reshaped the relationship between government, business, and individual liberty. How did a small bakery in Utica, New York, become the battleground for such a sweeping reinterpretation of the Constitution? And what was the fallout of a decision that would later be largely repudiated? Let's dive into Lochner v. New York. In 1905, in the heart of New York City, a loaf of bread cost around 5 cents. But the true cost of that bread was a deeply contested legal question, one that would pit the power of the state against the autonomy of individual businesses and, ultimately, shape the very fabric of American labor law for decades. Imagine a time when bakers, often working in sweltering, unsanitary conditions, toiled for unrestricted hours, their shifts stretching well beyond what we would consider reasonable today. This wasn't merely a matter of workplace preference. It was a societal issue that progressive reformers sought to address through legislation. This is the story of Lochner v. New York, a Supreme Court case that, while often overlooked in popular legal discourse, delivered a seismic shock to the progressive movement and profoundly influenced the interpretation of the 14th Amendment. It's a case that, even a century later, continues to spark debate about economic liberty, judicial activism, and the proper role of government in regulating private industry. For 32 years following this decision, the Supreme Court utilized the precedent set by Lochner to strike down nearly 200 state and federal regulations designed to improve working conditions and protect public welfare. Today, when we talk about minimum wage laws, occupational safety standards, or even the right to unionize, we are, in a very real sense, standing on the ground that was either fortified or fractured by the principles debated in Lochner. It represents a crucial chapter in the ongoing narrative of how America balances individual freedom with collective well-being. Our journey into this landmark case begins not in the hallowed halls of the Supreme Court, but in the bustling bakeries of New York, specifically with a man named Joseph Lochner and a law known as the Bakeshop Act. For 12, even 14 hours a day, in environments that were not only unsafe for them but dangerous for the public. This was the backdrop of early 20th century America, a period marked by rapid industrialization, vast wealth disparities, and the burgeoning progressive era. Social reformers and labor activists were increasingly challenging the laissez-faire capitalism that had defined the Gilded Age. They looked at industries, particularly the burgeoning bake shops, and saw a crisis. Journeyman bakers, many recent immigrants, frequently worked in what were known as bakeshop tenements. These were often basements or poorly ventilated ground floor spaces, where temperatures could soar to 90 or even 110 degrees Fahrenheit. Workers typically endured 12 to 14-hour shifts, 6 days a week, surrounded by conditions ripe for contamination. Beyond the immediate hardship for the bakers, these conditions posed a significant public health risk. Bread was, and remains, a staple food, and these unsanitary bakeries, often infested with rodents and cockroaches, were documented breeding grounds for disease. Concerns over tuberculosis and other contagions spreading through the food supply galvanized reformers. In response, New York State passed the Bakeshop Act in 1895. This landmark legislation, championed by the Bakers' Union and various social reformers, specifically aimed to improve health and safety by limiting bakery work to a maximum of 10 hours per day and 60 hours per week. This legislative effort was a direct challenge to the prevailing notion of unlimited employer control, setting the stage for a dramatic legal confrontation regarding a baker's alleged freedom versus public welfare. Against this tumultuous backdrop, one man, Joseph Lochner, a German immigrant and proprietor of the Lochner's Home Bakery in Utica, New York, became a central figure. Lochner repeatedly defied the recently enacted New York Bakeshop Act of 1895, which limited bakery employees to a maximum of 10 hours per day and 60 hours per week. He was cited and fined multiple times, first $25, then $50 for these violations. Lochner's legal challenge was not about the modest fines. It was a fundamental stand on what he viewed as his liberty to contract with his employees. He argued that the Bakeshop Act was an unconstitutional intrusion on this fundamental right, representing the broader employer's perspective that the government had no business dictating the terms of employment. The case progressed through the New York state courts. Lochner's initial conviction was ultimately upheld by the New York Court of Appeals in a 5-4 decision, highlighting the significant division even at the state level regarding the act's constitutionality. The state of New York, represented by District Attorney George W. Stedman, contended that the Bakeshop Act was a legitimate exercise of its police power, the inherent authority of a state to enact laws promoting public health, safety, and general welfare. They argued that long hours in unsanitary bakeries not only endangered the workers, who often suffered from respiratory illnesses, but also posed a risk to the bread-consuming public. This legal battle, framed as a clash between individual economic freedom and the state's duty to protect its citizens, set the stage for one of the most consequential Supreme Court decisions in American history. Permitting an employee, Frank R. Schultz, to work over 60 hours in a week. These citations led to the landmark Supreme Court case of Lochner v. New York, directly challenging the Bakeshop Act's constitutionality. In a narrow 5-4 decision, Justice Rufus Peckham, for the majority, struck down the New York Bakeshop Act as unconstitutional. The court cited a violation of liberty of contract, implicit in the 14th Amendment's due process clause, deeming the act an unreasonable, unnecessary, and arbitrary interference with the freedom to contract for labor. Peckham concluded baking was not an inherently unhealthy trade justifying such state intervention. Justice Oliver Wendell Holmes, Jr., famously dissented, declaring, "The 14th Amendment does not enact Mr. Herbert Spencer's social statics," accusing the majority of imposing their economic theories. Justice John Marshall Harlan, in his dissent, presented extensive medical and statistical evidence documenting the dangers of bakery work, arguing the act was a valid exercise of the state's police power to protect public health. Nevertheless, liberty of contract prevailed, ushering in the Lochner era, a period defined by rigorous judicial scrutiny of economic regulations and a legacy of deregulation. In the 14th Amendment's due process clause. This decision ushered in what became known as the Lochner era, a period from 1905 to 1937, where the Supreme Court frequently invalidated state and federal economic regulations. During this era, the court consistently prioritized what it termed liberty of contract and economic substantive due process, striking down over 200 laws. These included crucial minimum wage laws, as well as child labor laws, notably in the 1918 case of Hammer v. Dagenhart. The court's rationale was that such statutes interfered with the individual's freedom to negotiate employment terms. This judicial philosophy significantly hindered both progressive-era reforms and, later, President Franklin D. Roosevelt's New Deal programs designed to address the Great Depression. The constant clashes between the court and legislative bodies, particularly over New Deal legislation, escalated into a constitutional crisis, prompting widespread calls for judicial reform and even proposals for court packing. The era marked a deep tension between judicial interpretation of economic freedom and legislative attempts at social welfare, a tension that would eventually reach a critical breaking point, leading to what many constitutional historians call the switch in time that saved nine, and signaling the beginning of the end for Lochner's enduring legal legacy. Dead laws establishing minimum wages, regulating working hours, and even prohibiting child labor. However, this expansive interpretation of liberty of contract by the court was not without its challengers, particularly as the nation grappled with the economic realities of the Great Depression. The tide began to turn in 1937, a pivotal year often referred to as the switch in time that saved nine. This phrase alludes to the Supreme Court's dramatic shift in its constitutional interpretation. A key moment came with the case of West Coast Hotel Co. v. Parrish. In a 5-4 decision, delivered on March 29, 1937, the court upheld a Washington state minimum wage law for women, effectively overturning Adkins v. Children's Hospital from 1923, which had relied heavily on Lochner's principles. This marked a significant departure from the Lochner era, as the court began to defer to legislative judgments on economic matters, acknowledging the government's broad power to regulate for public welfare. While Lochner was formally repudiated in economic contexts, its ghost, the concept of substantive due process, later re-emerged in different areas. Notably, it was invoked to protect privacy rights in landmark cases such as Griswold v. Connecticut in 1965 and Roe v. Wade in 1973. This repurposing of substantive due process has fueled ongoing debate among legal scholars. Today, the term Lochnering remains a pejorative in constitutional law, symbolizing judicial overreach and the imposition of personal economic philosophy over legislative will, serving as a cautionary tale about judicial activism. This gradual shift ultimately led to the overturning of the Lochner precedent, most notably by cases like West Coast Hotel Co. v. Parrish in 1937, which upheld a state minimum wage law, and United States v. Darby Lumber Co. in 1941, which fully embraced federal power to regulate labor conditions. While Lochner v. New York is no longer considered good law in the context of economic regulation, its specter continues to loom large in American constitutional jurisprudence. It remains a powerful cautionary tale against judicial overreach and the dangers of a court substituting its own economic philosophy for that of a democratically elected legislature. Yet, the underlying concept of substantive due process, the idea that certain fundamental rights are so deeply ingrained in our traditions, and conscience that the government cannot infringe upon them without a compelling justification, persists. It simply shifted from economic liberties to personal liberties, as seen in cases like Griswold v. Connecticut and Roe v. Wade. The enduring debate over Lochner isn't just about labor laws from a century ago. It's about the appropriate role of the judiciary in a democratic society. It asks where the line should be drawn between protecting individual rights and deferring to legislative judgment. Considering how profoundly Lochner shaped legal thought, and then how it was dismantled, do you think any current judicial philosophies might eventually be viewed as a new Lochner era? Let me know in the comments below. For more deep dives into the cases that changed American law, subscribe to the channel. And if you found this analysis insightful, then my breakdown of the switch in time that saved nine, specifically West Coast Hotel Co. v. Parrish, is exactly the next thing you should watch to understand how the court ultimately moved away from Lochner's precedent. This video presents publicly documented information. It is for educational purposes, not legal advice.